So a case challenging the NFA and its restrictions on SBRs is now in front of the Supreme Court. The Supreme Court also recently took interest in this challenge and demanded that the Trump DOJ respond to this case. And also good news for this challenge is multiple two-way organizations have jumped in support of striking down the NFA and its restrictions on SBRs. So let's break down what is happening in this critical challenge. Now, before we jump into this video, I want to thank the sponsor of this video, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. They support what we do here on the channel. They support the Second Amendment. They're pro-freedom, pro-America. One of the really cool things about them also is the culture that they have within the organization, within the company. It bleeds over into everything they do, including their products. I love their products. I use their protein powder every time I work out. My favorite is the Formula 1 mint chip flavor, but also I really enjoy their pre-workout as well. And also, if you order something over $100, you can get free shipping. And they also do a 100% money back guarantee. If you don't enjoy your products and you want to return them, they will give you no hassle if you want to return those. So again, check them out using the links down below. As I mentioned in the intro, in this video, we're going to be talking about a new case and a very important NFA challenge that is now pending in front of the Supreme Court. This case is called U.S. versus Robinson, and it's a challenge to the NFA and its SBR restrictions. In this petition just filed by the plaintiff here, he asks that the Supreme Court find that the NFA's restrictions are unconstitutional under the Second Amendment as they apply to SBRs. This is a case that was ruled on by the 11th Circuit Court of Appeals, and now it's a ruling that's in front of the Supreme Court. And here they're asking for the Supreme Court to strike down this NFA restriction. Recently, the Trump DOJ decided to waive their right to reply to this case, and the Supreme Court then set conference to happen in this challenge. However, then the Supreme Court decided to issue an order responding to the Trump DOJ, and they ordered that the Trump DOJ file a response to this case here, and they ordered that they respond to the NFA and SBR challenge. And so that's great news because the Trump DOJ will now have to respond to this challenge. And also great news for this case is multiple two-way organizations have jumped in support of the plaintiff and in support of striking down the NFA. Now, the facts around this case are very interesting. Essentially, back in September 9th, 2022, law enforcement officers responded to a complaint of a suspicious vehicle that was parked outside of a home, I believe in Florida. When the officers arrived, they observed that Mr. Robinson was asleep in the vehicle. He was asleep in the car, and they also shined a light in there, and they saw that there was a rifle and a buttstock. When officers searched the vehicle, they found a loaded short-barreled rifle and a separate upper receiver. That one, I believe, was a 16-inch barrel on that upper that was separate, but the one that they recovered that was, full and complete was an SBR. They then searched the National Firearms Registration and Transfer Record, and it revealed that the SBR was not registered under the NFA. And because of that, he was charged with violating the NFA and having an unregistered SBR. Now, Mr. Robinson was then charged and eventually convicted after a bench trial, and they imposed a sentence of 18 months probation and 6 months of house arrest. Robinson then appealed his conviction to the 11th Circuit Court of Appeals, and on appeal, he argued that the statute and his conviction violated the Second Amendment in light of New York State Rifle and Pistol Association versus Bruin, and he claimed that there was no text, history, or tradition to support the NFA's taxation and registration scheme. However, on review, the 11th Circuit rejected all of Mr. Robinson's claims, finding that the NFA did not violate the Second Amendment. Now, that decision by the 11th Circuit not only rejected the Second Amendment challenges to the NFA and the whole restrictions on SBRs, but also they claimed that the NFA is, not unconstitutional, that it's still constitutional, and it operates as a constitutional tax. On the Second Amendment question, they relied heavily on the Supreme Court's Miller decision. They stated that Miller already found that short-barreled shotguns are dangerous and unusual firearms, and therefore they could be restricted, and they believe there is no meaningful distinction between SBSs and SBRs, and therefore Miller stands as valid precedent as also applied to short-barreled rifles. They stated that until the Supreme Court changes their decision or clarifies the SBR issue, they are bound by what Miller said. Now, in rejecting the tax argument, they claimed that Bruin's decision forecloses that type of argument since Bruin contemplated that some objective restrictions like fees and taxes and tests could be permissible under the Second Amendment. Therefore, they struck down the tax argument and said that you could not bring that type of challenge against the NFA, and you could not bring that under the Second Amendment. That horrible ruling is now up for review and consideration in the Supreme Court. Now, in this petition, the two questions presented for the Supreme Court to consider are whether federal criminal punishment of the possession of an unregistered short-barreled rifle violates the Second Amendment. Also, whether federal criminal punishment of the possession of an unregistered SBR rifle exceeds Congress's taxing powers under Article 1, Section 8. In the petition, Mr. Robinson rejects the notion that Miller stands for the complete argument that SBRs are not protected arms. He argues that since SBRs are protected arms, the federal government bears the burden under Bruin to essentially show that there is a history and tradition to support this type of registration and taxation scheme. He argues that there is no text, history, or tradition to support this type of NFA restriction. Now, recently, like I mentioned, the Trump DOJ filed a waiver. They said that they were not going to respond to the petition, but recently the Supreme Court ordered that the Trump DOJ file a response, and that is now currently due on October 20th, since the Trump DOJ recently also got an extension from the Supreme Court. Now, something else also developing in this case is the fact that multiple 2A organizations have jumped in support of Mr. Robinson. GOA and multiple 2A organizations also just recently filed an amicus brief to the Supreme Court arguing that they should take up this NFA case and ultimately strike down the NFA as it applies to SBRs. Now, they argue in that amicus brief that the framers never would have permitted an otherwise law-abiding American to become a felon simply because, unbeknownst to him, the barrel of his rifle measured a few inches shorter than some arbitrary governmental standard. Yet that is the procedural posture of this case, a felony conviction for possession of an unregistered short-barreled rifle under the NFA. To be sure, the NFA does not completely ban short-barreled rifles. It restricts their ownership through taxation and registration. But this tax applies only to Americans' exercise of an enumerated right, something that this court has repeatedly disallowed in other contexts. This court's intervention is necessary to right this wrong and to correct the numerous methodological errors that are running rampant in the lower courts. So like I mentioned, this is good news because you have the Supreme Court ordering that the Trump DOJ respond to this case. They were extended some time, so they have some additional time, but now you also have multiple organizations jumping into support of Mr. Robinson, arguing the Supreme Court should take this case. Now, this is the second NFA and SBR Second Amendment challenge that has been to the Supreme Court, that's been sent to them to review this whole SBR NFA issue. This is also the second time the Supreme Court has ordered that the Trump DOJ file a response, and they said that they're now going to consider this after conference. Now, the response, like I mentioned, is due on October 20th, and now multiple 2 organizations are supporting this case, so this is all good news, and it shows that this issue is being taken serious by the Supreme Court, and this is moving forward at the highest level at the Supreme Court level. Also, with the recent NFA tax change through the One Big Beautiful Bill with the reduction of the $200 tax all the way to $0, this kind of creates a unique dilemma and situation that maybe then piques the Supreme Court's interest and makes them want to get involved in this issue. So that's what's currently going on in this new NFA SBR challenge that is currently pending in front of the Supreme Court. The Supreme Court ordered that the Trump DOJ respond to this. The Trump DOJ got some extensions. You have organizations jumping in to support this case, and now it's going to be interesting to see how does the Trump DOJ respond to this? How do they argue in that response brief, and what position do they take? So as this develops, as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out our sponsors, like I mentioned at the beginning, First Form. They support the channel, so you can check them out using the links down below. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.